Hello friends, welcome to this session of Law of Evidence. This is the 8th video in the series and the last one on the first chapter of the Indian Evidence Act. In this session, we will be discussing about section 4 of the Law of Evidence. Now section 4 is a very important section as it defines three terms which will come again and again in the various substantive laws. One is may presume, another is shall presume, and third is conclusive proof. A comparative analysis of all these three terms is necessary in order to understand their complete implications. First of all, we will go through the bare act and see what is exactly written in it regarding these three terms. So, as far as the word may presume is concerned, it is stated whenever it is provided by this act that the court may presume a fact, it may either regard that fact as proved unless and until it is disproved, or may call for proof of it. So, whenever there is the term may presume, that the court may presume a fact, the court has got two options. First option is that it may take it as proved, and it will remain in that case proved until and unless it is disproved. That is, the court, if it takes the first option, that is, take it to be proved, it will allow the other party, if it wants to rebut it, then the other party can rebut it. But until and unless it is disproved by the opposite party, the court may take it to be proved. Another option which is available to the court in this case is that the court may ask for proof of it. The court may not take it granted to be proved, rather the court may ask for proof of it. So therefore, there are two options before court when it is dealing with the term where may presume is there. One, it may take it to be proved, and another, it may call for proof of it. But where it takes it to be proved, it will allow the opposite party to disprove it. Now another term is shall presume, and it is stated whenever it is directed by this act that the court shall presume a fact, it shall regard such fact as proved until and unless it is disproved. So in case where shall presume is written, the court does not have the other option, that is to call for proof of it. It is mandatory for court to take it to be proved. However, it will allow the opposite party to give evidence against it, to disprove it. And third is conclusive proof. When a fact is declared by this act to be conclusive proof of another, the court shall, on proof of one fact, regard the other as proved and shall not allow the evidence to be given for purpose of disproving it. Now, in case of conclusive proof, the court has got two duties. One, that if the act states that fact 1 is conclusive proof of fact 2, then once the fact 1 is proved, it will take fact 2 as to be proved itself. Not only this, the word is and it shall not allow any evidence by the opposite party for disproving this fact too. That is in case of conclusive proof. So may presume, the court has got two options: to take it to be proved or ask for proof of it. And the opposite party can disprove it in case it is taken to be proved. In case of shall presume, the court has got the option of taking it to be proved, but the other party has got the liberty to disprove it. But in case of conclusive proof, if one fact is said to be the conclusive proof of another fact, once the first fact is proved, the other fact will be taken to be proved, and the court will not allow any evidence to be given for purpose of disproving it. Now, we will have an overview of what all we are going to discuss in this session. One is that we will discuss the definition of presumptions. That is, what is meant by this term presumptions. Then we will also discuss the importance and effect of the word presumption. Then the basis on which presumptions are drawn, the various types of presumptions, and presumptions of law and fact, the distinction between the two, a comparative analysis between the two. So let us start. The definition of word presumption is that presumption is an inference of fact drawn from other known or proved facts. So it is an inference that if first thing is there, and first thing is that it leads to the second thing, then if first thing is proved, we can presume the second fact. For example, if it is said that an event took place in open, that is in open field, and then it is said that it was daytime, the presumption can be taken that there was enough visibility and there was no darkness around. So once it is proved that it took place at noon and it took place in open field, then the presumption can easily be drawn that there was good visibility. An example of presumption is that suppose there is a man and a woman and they are found alone in suspicious circumstances in a room. They are closed. The law presumes that they are not there to say their prayers, though in the present world they may be engaged in their mobile phones. That apart, and the divorce law would take this as evidence of adultery. So the natural course of business is that if man and women, or natural human conduct is that if a man and women are found in a suspicious circumstances in loneliness with both of them together, then it can be presumed that there is some adultery going on, and the divorce law of this can take effect. But mind you that this can always be disproved also. Now, what is the effect or importance of the word presumption or the term presumption being taken? The effect is that it shifts the initial burden of proof. That is, when a presumption is drawn in favor of, say, party A, there are two parties, party A and party B, and suppose presumption is drawn in favor of party A, then the burden of proof now shifts to B. Rather, the onus of proof now shifts to party B. So the party in whose favor a fact is presumed is relieved of initial onus of proof. The burden of proof shifts on the other party. So it acts as a prima facie evidence of the matter. But if the opposite party gives evidence to rebut the presumption, then the onus of proof may again come to party A. So the presumption effect of it, the importance of it is that it shifts the onus of proof on the other party. However, when the other party gives evidence in his favor, then certainly the onus of proof shifts back to party A. So it is said that presumption holds the field in absence of evidence, but when facts appear, presumptions disappear. Friends, they may ask short note on this to describe it, that when facts appears, presumptions disappear. So you can explain what is presumption and what are the effect of presumption and how the initial burden of proof or onus of proof shifts. Now, what are the bases on which the presumptions are drawn? So there are three important bases on which presumptions are drawn. That is common course of human conduct. So the common human behavior, that is one of the basis of the presumption. The natural events, common course of natural events, that if there is thunder, there is lightning, then maybe there is rain. If it is a winter night, a winter morning at 5 o'clock, and it was so cold in the night, it may be presumed that there is fog. If there is fog, it may be presumed that there was low visibility. So these are natural events and common course of business. So basis of presumptions are human conduct, common course of human conduct, common course of natural event, and common course of business. Now, what are the various types of presumptions? Friends, presumptions are basically of two types: presumption of fact and presumption of law. Though one more third type is also applicable in English common law, and that is a mixed presumption of law and fact. But we will concentrate on these two types as are applicable in Indian laws, that is presumption of fact and presumption of law. Now, presumption of fact is what is given by the term may presume. While presumption of law are of two types, shall presume and conclusive proof. Now, one difference in comparative analysis of this is that discretionary. Presumption of fact, wherever there is may presume a fact, it is discretionary on court. The court may take it to be proved or may ask for proof of it. But wherever there is shall presume, the court has got no discretion. It is obligatory for the court to take it to be proved until and unless certainly it is disproved in case of shall presume. Similarly, wherever there is conclusive proof, there is no discretion on the court. It is obligatory for court to take that matter to be proved, and here in this case it won't even allow any evidence to disprove it. Next is rebuttable. The presumptions of facts, wherever there is may presume, are rebuttable in nature. And if the court takes it to be proved, the opposite party is free to give evidence to rebut it. Same is the case with shall presume. Though the court it is obligatory for court to take it to be shall presumed, yet it is rebuttable in nature. Rebuttable in nature means the opposite party can give evidence to rebut it. But wherever there is conclusive proof, then it is obligatory as well as it is irrebuttable. The opposite party is not at a freedom to give any evidence to disprove it. Now, there are certain examples to it. For may presume, it can be taken that examples under section 114 of Indian Evidence Act. For example, if a person is in possession of a stolen property and he cannot account for it, then it may be presumed that either he is the thief or he has got the property knowing that it is a stolen property. Then one example of shall proof is section 105 of Indian Evidence Act, where it states that if an offense is done, then the court shall presume absence of any exception laid down in the Indian Penal Code. Another is section 114A, that in case of rape, absence of consent shall be presumed. Then Section 118 of NIA, Negotiable Instrument Act, is also a shall presume. Next is conclusive proof. These are very four important examples which are asked time and again in examination, and it was asked by me also in my interview examination of judicial services. So Section 41 of Indian Evidence Act gives certain conclusive proof with regard to insolvency, matrimony, admiralty, and the probate. Some judgments regarding it are taken to be conclusive proof. Similarly, Section 112 of Indian Evidence Act, where legitimacy of child is conclusive proof. Section 113, cession of territory, is also certain times valid cession of territory. It is also a conclusive proof. And another is that Section 82 of Indian Penal Code, where it is a conclusive proof that child below the age of 7 will not have the mens rea to do a crime. Now, there is a case, that is Dr. Akhil Kumar versus State. Now, in this case, the doctor gave an injection for termination of pregnancy. It resulted in the death of the woman. The doctor was held liable. It was presumed that the doctor should know, a doctor is supposed to know the side effect of the medicine which is given by him, because he is an expert, he is informed of it, he is taught about it. So, a doctor, it may be presumed that the doctor knows the side effect of a medicine. So, we will just quickly recap what all we had done in this session. That Section 4 of Indian Evidence Act deals with the term may presume, shall presume, and conclusive proof. May presume, it is the court may either regard it as to be proved or ask for proof of it. Shall presume, it is obligatory for court to take the matter as proved. Conclusive proof, the one fact is proved, the other fact it will be taken to be proved, and court will not allow any evidence for disproving it. The word presumption means that an inference can be drawn from a fact which is known or proved. Then the effect of it is that there is shift of initial onus of proof to in favor of the party which in whose favor the presumption is made. So prima facie, presumption furnishes an evidence. But once facts appears, presumption disappears. Now the basis of presumption are that it is common course of human conduct, natural event, and business. There are two types of presumption: presumption of fact and presumption of law. Presumption of fact is may presume, and it is discretionary and irrebuttable. Presumption of law is maybe either shall presume or conclusive proof. Shall presume, it is obligatory and rebuttable, while in conclusive proof it is obligatory but irrebuttable. Then in case of Dr. Akhil Kumar versus State, we saw that it shall be presumed that the doctor knows the side effect of the medicines as such. Thank you, friends.